हेलो गाइस, वेलकम टू एसके लीगल व्लॉग्स। आज के एपिसोड में फ्रेंड्स हम बात करने वाले हैं कुछ इंपॉर्टेंट सेक्शंस ऑन द सब्जेक्ट ऑफ इंडियन एविडेंस एक्ट 1872। तो फ्रेंड्स, अगर आप जुडिशरी की प्रिपरेशन कर रहे हैं या फिर एक लॉ स्टूडेंट हैं तो कंप्लीट बेल एक्ट को गोन थ्रू करना एक काफ़ी डिफ़िकल्ट स्ट्रेटजी प्रोसेस है। तो इस वीडियो में मैं आपको कुछ इंपॉर्टेंट सेक्शंस लेके आया हूँ फ्रेंड्स, जो कि आप स्क्रीन पर देख रहे हैं। और कंप्लीट बेल एक्ट जो भी इंपॉर्टेंट सेक्शंस हैं, आज मैं उसको उन सबको आपसे शेयर करने वाला हूँ। तो फर्स्ट ऑफ ऑल फ्रेंड, जो मेन सेक्शन है वो सेक्शन 3 है, विच डील्स इन फैक्ट एंड इशू, रेलेवेंट फैक्ट्स, डॉक्यूमेंट्स एंड एविडेंस। इनमें इन सब की डेफिनेशंस बेसिकली दी गई है। सेकेंड मेन सेक्शन इज 4। सेक्शन 4 इज विद रिस्पेक्ट टू मे प्रिज्यूम, शैल प्रिज्यूम एंड कंक्लूसिव प्रूफ। Section 5 pertains to evidence may be given of facts in issue and relevant facts. Section 6 to 13 is with respect to res gestae. This is a very important questions which is start from section 6, which is respect to relevancy of facts forming part of same transaction, which is known as res gestae. Section 7 is facts which are in the occasion, cause or the effect of facts in issue. Section 8 is motive, preparation and previous or subsequent conduct. Section 9 is facts necessary to explain or introduce relevant facts. Section 10 is things said or done by the conspirator in reference to a common design. And Section 11 is when facts not otherwise relevant become relevant. And Section 12 is when suits for damages, facts tending to enable court to determine amount are relevant. And Section 13 is with respect to facts relevant when right or custom is in question. Friends, in detail, we will discuss this in separate videos. So our next main heading is admission and confession. The definition of admission has been given in section 17, and section 18 says admission by party to proceedings or his agent. Section 19 deals in admission by persons whose position must be proved as against parties to suit, and section 20 says admissions by persons expressly referred to by parties to the suit. So section 17 to section 20 deals with the concept of admission in the Indian Evidence Act. Now section 24 says for confession. Confession, section 24 provides mainly for confession caused by inducement, threat or promise when irrelevant in criminal proceedings. Section 25 is confession to a police officer not to be proved. Section 26 is confession by accused while in custody of police not to be proved against him. Thereafter, the next main topic is dying declaration, which has been covered in section 32 subsection 1 of the Indian Evidence Act. Next main heading is relevancy of judgment, which are discussed under sections 40 to 44, in which section 40 provides that previous judgments relevant to bar a second suit or trial. Section 41 is with respect to relevancy of certain judgments in probate, etc. jurisdiction. Section 42 is relevancy and effects of judgments, orders or decrees other than those mentioned in section 41. Thereafter, section 43 provides judgment, etc. other than those mentioned in section 40 to 42 when relevant, as we discussed above in the relevancy of judgments. Thereafter, section 44 says fraud or collusion in obtaining judgment or incompetency of court may be proved. Next main heading is opinion of experts, opinion of third persons, or we can say experts' opinion. This is a very main concept which will we cover in our separate video. So next, section 45 is opinions of experts. Section 46 is facts bearing upon opinion of experts, and section 47 is says opinion as to handwriting when relevant, that is really comes into practice in courts. Next is section 52 to section 55, which says about the conduct and character of parties. Section 52 provides in civil cases character to prove conduct imputed irrelevant, and section 53 says in criminal cases previous good character relevant. Section 54 deals in previous bad conduct not relevant. So basically the difference between section 53 and 54 is that section 53 provides in criminal cases previous good character is relevant, and in 54 previous bad character not relevant except in reply. Next is section 55, as to character as affecting damages. Next, section 56 and 57 are with respect to judicial notice. Section 59 and 60 and other pertains to mainly oral evidence. As to what is the oral evidence, basically there are two types of evidence, that is oral evidence and documentary evidence. So oral evidence have been discussed in section 59 and 60, and thereafter all type of documentary evidence have been discussed as you are watching on the screen in section 61 to 78, where 61 says proof of content of documents. 62 provides primary evidence, definition of primary evidence. Section 63 provides definition of secondary evidence. 64 says proof of documents by primary evidence. Section 65 is cases in which secondary evidence relating to documents may be given. And section 65A is special provisions as to evidence relating to electronic record. Section 65B is admissibility of electronic records. Now section 74 says public documents. 75 is private documents. 76 is certified copies of public documents. 77 is proof of documents by production of certified copies. 78 says proof of other official documents. Next main heading is exclusion of oral by documentary evidence. Section 91 says evidence of terms of contracts, grants and other dispositions of property reduced to form of document. Next important section is 92, exclusion of evidence of oral argument. And thereafter the main topic, very important for the examination point of view, is burden of proof, as to whom the burden will be when any document is to be required to be proved in courts. That has been discussed under section 101 to 106, which you are watching on the screen. And next main heading is estoppel, which section 115 and 116 says, as the definition of estoppel has been provided in section 115, and 116 provides that estoppel of tenant and of license of person in possession. Next is competency of witness, as to who is a competent as a witness. So section 118 provides only as to who may testify. Section 119 is dumb witness. Section 120 is with respect to parties to civil suits and their wives or husbands or wife of person under criminal trial. Next is privileged communications, which has been discussed under section 121 to 129, as various kinds of communications which are privileged has been given in these sections, and that we will discuss in another separate video. So next is examination of witnesses, which has been given 137, and 138 139 also important, you may note. Next is leading questions, which has been provided in the section 141 to 143. That is 141 says about leading questions, and section 142 is when they must not be asked, as to when the leading question not to be asked, and section 143 is when they may be asked. So friends, these were the important questions on this subject, and the separate videos on this subject shall be shared with you very soon. Thanks for watching this video.